Today's update is about a 2025 case from the Ninth Circuit Court of Appeals, the estate of Soakai v. Abdelaziz, case number 23-4466, May 16, 2025, addressing qualified immunity in the context of police pursuits and the resulting harm to non-involved bystanders. The case arose from a 2022 incident in Oakland, California, where Lolomanaia Soakai, a 28-year-old bystander, was killed when a fleeing suspect lost control of his vehicle during an unauthorized high-speed police pursuit and crashed into a group of bystanders. On June 25, 2022, Oakland police officers Waleed Abdelaziz and Jimmy Marine Coronel initiated a ghost chase, an unauthorized high-speed pursuit without sirens or lights, against a suspected participant in an illegal car rally, despite departmental policies restricting such chases to only certain violent crimes. The officers never alerted any other units or dispatched to their self-initiated pursuit. Speeds exceeded 60 miles per hour through crowded urban streets. The suspect's car crashed near a parked taco truck, killing Lolomanaia Soakai and injuring his mother, Lavinia Soakai, and 3 other bystanders. Despite observing the scene and the victims, the officers did not summon aid or activate light-sirens. Instead, they fled the scene, only to return later, claiming to have just arrived, and expressed satisfaction that the suspect had been injured. The plaintiffs, including the estate of the deceased and several injured parties, brought a 42 U.S.C. Section 1983 civil rights action against the 2 officers, alleging violations of their 14th Amendment substantive due process rights under 2 distinct theories. 1. A purpose to harm claim, asserting officers conducted the chase with intent to harm the suspect in a manner exceeding legitimate law enforcement purposes, and 2. A state-created danger claim, alleging officers failed to summon or render emergency services after witnessing the crash injuries. As to these claims, the 14th Amendment's Due Process Clause protects individuals from government conduct that shocks the conscience. In the law enforcement context, courts typically apply this standard by examining whether officers' actions serve legitimate governmental purposes or exceed constitutional bounds. As for the state-created danger doctrine, over time it has evolved from requiring direct government creation of danger to encompassing situations where government actors contribute to dangerous situations and then fail to respond appropriately. This case has expanded the doctrine to include duties to render aid to non-involved bystanders, represents a significant doctrinal development with implications for law enforcement liability. The United States District Court for the Northern District of California denied the defendant officer's motion for judgment on the pleadings based on qualified immunity. The officers appealed to the Ninth Circuit, arguing they were entitled to qualified immunity because plaintiffs failed to state a claim for constitutional violations. Qualified immunity bars liability unless A. Officer violated a constitutional right, and B. The right was clearly established at the time of conduct. Pearson v. Callahan, 555 U.S. 223, 2009. The Ninth Circuit affirmed the District Court's denial of qualified immunity, establishing 2 significant precedents. 1. Purpose to harm theory for bystander claims. The majority of the court held that bystanders injured during police pursuits can state a viable substantive due process claim by alleging officers conducted operations with a purpose to harm suspects that exceeded legitimate law enforcement purposes. Critically, the court rejected the defendant's argument that bystanders must specifically allege officers intended to harm them personally. The court reasoned that circuit precedent recognizes officers owe duties to all persons in the vicinity, including bystanders, to limit their intent to harm to legitimate law enforcement purposes. This represents an expansion of substantive due process protections, allowing third-party harm claims based on improper intent toward different individuals. As a reference, the United States Supreme Court in County of Sacramento v. Lewis, 523 U.S. 833, 1998, held that executive action must be deliberately indifferent or intentionally harmful for reasons unrelated to legitimate objectives to breach due process standards. The Ninth Circuit took this duty further in this case. Second state-created danger doctrine extension. The court also affirmed liability under the state-created danger doctrine, holding that officers who affirmatively create dangerous situations through their conduct can be held liable for subsequent deliberate indifference to resulting injuries. Specifically, the court found that officers who initiate pursuits leading to crashes, then fail to summon emergency aid despite witnessing injuries, violate clearly established constitutional principles. Central to the qualified immunity determination was whether the law was clearly established at the time of the 2022 incident. The majority concluded that existing precedent sufficiently established both the purpose to harm theory for bystander claims and the duty to render aid under state-created danger circumstances. This finding allowed the constitutional claims to proceed despite qualified immunity assertions. Judge Bumatai authored a vigorous dissent, arguing the majority improperly expanded constitutional protections beyond established precedent. The dissent characterized the majority's purpose to harm holding as creating an unprecedented theory of substantive due process, arguing it conflicts with Supreme Court precedent limiting such claims. Judge Bumatai contended that allowing bystanders to assert due process violations based on officers' intent to harm other individuals represents judicial overreach inconsistent with the Supreme Court's qualified immunity framework. The dissent also criticized the majority's expansion of the state-created danger doctrine, arguing it improperly creates new constitutional duties requiring law enforcement to render medical aid. The dissent noted this expansion moves beyond traditional requirements of affirmative conduct by a state actor that exposed plaintiffs to actual particularized danger to encompass broader duties based on causal connections to harm. This decision reflects ongoing tensions within qualified immunity jurisprudence. The Supreme Court's qualified immunity framework requires that constitutional violations be clearly established at the time of the alleged misconduct. The Soakai majority's finding that both theories were clearly established represents an aggressive application of this standard with reduced deference to law enforcement in civil rights litigation. The case's ultimate impact will depend on subsequent judicial interpretation, potential Supreme Court review, and law enforcement community responses. However, Soakai clearly signals increased judicial scrutiny of police conduct and reduced tolerance for actions that exceed legitimate law enforcement purposes, particularly when innocent bystanders suffer harm. Ghost chases, especially without lights or sirens, are extremely risky and may expose agencies and individual officers to Section 1983 liability when they result in bystander harm. Even absent intent to kill, intentionally reckless actions that create and abandon a danger are sufficient to shock the conscience. Agencies must train and enforce strict adherence to pursuit policies, and officers should know they may face civil liability and loss of immunity for priority-based disregard for safety. Overall, this case came to fruition by the stupidity of an unauthorized pursuit and the dereliction of duty to serve the community by leaving the scene after the suspect killed the bystander. Substantive due process evolution. The purpose to harm theory represents a notable expansion of substantive due process protections. Traditional analysis focuses on whether government actors' conduct shocks the conscience or violates fundamental rights. By allowing third-party harm claims based on improper intent toward others, Soakai potentially broadens the scope of actionable constitutional violations. Sokai's analysis focuses on whether the officer's pursuit tactics served legitimate law enforcement goals or instead reflected improper intent to harm. This approach aligns with established precedent examining officers' motivations and the relationship between their conduct and legitimate governmental interests. Section 1983 Civil Rights Framework. Overall, 42 U.S.C. Section 1983 provides a cause of action for constitutional violations committed under color of state law. The statute requires plaintiffs to demonstrate that defendants, acting under color of law, deprive them of constitutional rights. Sokai's analysis confirms that bystander injuries resulting from improper police conduct can satisfy these elements when officers act with improper purposes. The dissent raises legitimate concerns about judicial expansion of constitutional protections beyond established precedent. The purpose to harm theory's application to third-party injuries represents a significant doctrinal development that may create uncertainty in law enforcement operations. The state of Soakai versus Abdelaziz represents a significant development in civil rights litigation against law enforcement, particularly regarding qualified immunity limitations and substantive due process protections for bystanders. The decision's expansion of both purpose to harm theories and state-created danger doctrine creates new avenues for civil rights claims while potentially influencing law enforcement practices and policies. Soakai clearly signals increased judicial scrutiny of police conduct and reduced tolerance for actions that exceed legitimate law enforcement purposes, particularly when innocent bystanders suffer harm. This is David for Tactics and Trials. Until next time, be safe.